The lawyer who thought my age was a weakness. He said it in front of everyone, in my own courtroom, into a live microphone, with a grin on his face like he had just said the cleverest thing anyone had ever said in a room full of lawyers. I hope your memory is holding up, Your Honor. At your age, that must be the hardest part of the job. The audience went silent. The bailiff went still. And I looked up from my papers very slowly, and I looked at him. I did not raise my voice. I did not slam my gavel. I did not give him the reaction he was performing for. I simply looked at him. And that was the moment he made his second mistake. Because his first mistake was the insult. His second was misreading my silence as weakness. He had no idea what was waiting for him inside that folder on my bench. If you believe that experience, real, earned, hard-won experience, still deserves respect in this world, please subscribe right now, because what happened next in that courtroom is something I think every person over 50 needs to see. Let me take you back to the beginning. His name was Nathan Voss, 41 years old, sharp dresser, television-ready haircut, the kind of attorney who walks into a room and immediately starts calculating how he can use it. He had been practicing law for 15 years, and in those 15 years, he had built a very specific kind of reputation, not for winning, not for justice, for performance. Nathan Voss was what I call a courtroom actor. He understood that in the age of cameras and social media, the most dramatic moment in a case was often more powerful than the verdict. He had learned to play to audiences. He spoke in sound bites. He timed his pauses like a stand-up comedian, and he had made a career out of choosing the right targets, people he could embarrass publicly in ways that made him look clever and them look small. His clients hired him not because he was the most ethical attorney they could find. They hired him because he was entertaining, because watching Nathan Voss dismantle someone in a courtroom felt like watching a magician work, dazzling, smooth, and by the time you noticed the trick, your wallet was already gone. I had heard his name before the case ever landed on my docket. 2 colleagues had mentioned him in passing, not admiringly, but carefully, the way people mention someone whose talent they acknowledge and whose character they do not trust. When I saw his name assigned to an upcoming case, I did something I do not always do. I made a few phone calls. What I found over the next 48 hours was not surprising, but it was thorough. 3 formal complaints filed against him by opposing counsel over the past 5 years, each one describing the same pattern: manufactured urgency, misrepresented facts, and a habit of ambushing witnesses with information he was not supposed to have yet. Every complaint had been quietly resolved. His firm was influential. His clients were wealthy. The complaints disappeared the way inconvenient things do when powerful people prefer silence. There was also a deposition transcript from a civil case 2 years prior, a transcript his own client had anonymously leaked after feeling betrayed. In it, Nathan had coached a witness with information he then presented as that witness's independent recollection. It was a careful fraud, small enough to be deniable, consistent enough to be a pattern. And there was one more thing, a letter written by a retired judge who had presided over one of Nathan's early cases. In the letter, this judge described asking Nathan to approach the bench after a particularly aggressive cross-examination of an elderly plaintiff. The judge had said, privately, that the behavior was beneath the standards of the profession. Nathan's response, according to the letter, was to smile and say, "The old ones don't fight back as hard. That's why I pick them." I read that line 3 times. Then I put the letter at the bottom of my folder beneath everything else, because I wanted to remember it when the moment came. I did not go into that courtroom angry. Anger is a fire that burns the person carrying it just as much as the target. I went in prepared, and there is a difference. Prepared is quiet. Prepared is patient. Prepared is a woman of 76 who has been doing this work since before Nathan Voss was born, holding a folder of facts and waiting for arrogance to walk through the door and introduce itself. He did not disappoint. He arrived 10 minutes early, which surprised me. I learned later it was intentional. He wanted to work the room before I entered. He shook hands with the clerk. He joked with the camera operator. He stood at the plaintiff's table with the relaxed posture of a man who had already decided how the day would go. When I walked in, he looked at me the way certain people look at things they have already categorized. Not hostility, dismissal. The particular kind of dismissal that doesn't even bother to disguise itself. I sat down. I arranged my papers. I greeted the room as I always do, and then I called the case to order. The matter before us was a contract dispute. A small business owner named Patricia Delgado, who was suing a home renovation company for abandoning a job halfway through and refusing to return her deposit. Nathan was representing the company. Patricia sat across from him, nervous, hands folded, a woman in her late 50s who had saved for 2 years to afford the renovation and was now fighting to get her own money back. I looked at her when she walked in. I noticed the way she held herself, carefully, like someone bracing for a blow she had already learned to expect. I noticed Nathan notice her the same way, and I watched something flicker across his face. Not empathy, recognition, the kind a predator has when it spots familiar prey. He opened a statement with exactly the kind of flair I expected. Confident, articulate, a little too rehearsed. He presented his client's position with smooth language that sounded reasonable on the surface and revealed its dishonesty only if you knew where to look. Then he glanced over at me with that particular expression, the one that says, "I am being patient with you," and said it. "I hope we can keep the proceedings moving at a good pace today, Your Honor. I know the afternoon light can make it difficult to stay sharp." He smiled at the camera. The room waited. I looked at him for a long moment, long enough for the room to feel the weight of it. "Thank you for your concern, Mr. Voss," I said. My voice was even, quiet. "I'll keep that in mind." He mistook my response for acceptance. He actually nodded, a small, satisfied nod, and turned back to his papers as if the exchange had confirmed something he already believed. It had, just not what he thought. I let him speak for several more minutes. I asked Patricia a few questions. I listened to her describe the renovation: a kitchen and 1 bathroom, a reasonable scope, a signed contract, a schedule that the company had simply abandoned after collecting 60% of the payment. I watched her hands as she spoke, steady at first, then trembling slightly when she described coming home one day to find the workers gone and her kitchen torn apart with no walls, no appliances, exposed pipes, and no communication from the company at all. She had 2 adult children, she mentioned. She had been hosting family dinners in that kitchen for 23 years. She had saved for this renovation specifically so the house would be ready before her youngest daughter's wedding. The wedding was in 6 weeks. Nathan interjected smoothly. The delay was caused by supply chain issues entirely outside my client's control. I looked at him. "I didn't ask you yet, Mr. Voss." He smiled again, that practiced, tolerant smile. "Of course, Your Honor." I turned back to Patricia and asked her one more question. "Did the company provide you with any written notice of the delay?" She shook her head. "No, ma'am. They just stopped showing up." "Did they return any portion of the deposit when they walked off the job?" "No." I nodded slowly. Then I opened my folder. "Mr. Voss," I said, "let's talk about your client's business practices." He leaned forward slightly, still confident, still performing. "I have here," I said, "a record of 7 prior complaints filed against your client's company with the State Contractor Licensing Board over the past 4 years. 5 of those complaints describe the identical pattern: collecting partial payment, performing initial work, and then abandoning the project without notice or refund." Nathan's smile thinned, just slightly. "Those complaints were reviewed and closed without action," I said. "Yes, I read that. I also read the reason they were closed. The complainants withdrew their complaints after receiving partial settlements." I placed the paper down carefully. "Do you know what that pattern is called, Mr. Voss?" He said nothing. It's called predatory contracting, I said. And the targets, as I'm sure you've noticed, are consistently homeowners over the age of 50, mostly women, mostly single. The room shifted. Nathan's jaw tightened. Your Honor, those settlements were reached voluntarily and Patricia Delgado was offered no such settlement, I said, because she hired an attorney who advised her to come to court instead, which is why she is sitting here today and which is why you are standing there with a much more difficult situation than you walked in expecting. He opened his mouth. I continued. I also have the contract your client signed with Ms. Delgado, specifically the completion clause on page 3, which states that in the event of abandonment without written notice, the contractor forfeits all payments received and owes an additional penalty of 15% of the total contract value. I looked up at him. Did you read the contract before you took this case, Mr. Voss? A beat of silence. Of course. Then you knew this clause existed. Another beat. There are arguments about the applicability of— There are no arguments, I said softly. There is a signed document. There is a clear clause. There is a woman whose kitchen has no walls 6 weeks before her daughter's wedding. And there is a company that has done this to at least 7 other people before her. I set the folder down and folded my hands. Now, earlier this morning, you expressed concern about whether I could stay sharp enough to follow the proceedings. I'd like you to tell me, was that an attempt at humor, or were you genuinely unsure whether I was capable of reading a contract? The courtroom was absolutely still. Nathan looked at me for the first time without performing, without calculating, just looked. It was inappropriate, he said finally. The words came out quietly, which told me more than any loud response would have. Yes, I agreed. It was. I want to stop here for a moment. I want to speak to you directly, because I know some of you watching this have had your own version of that moment. A moment when someone looked at your age, or your gender, or both, and decided you were no longer worth full respect. A moment when someone spoke to you like you were a step behind. A moment when you felt the sting of being underestimated by someone younger and louder and convinced of their own brilliance. I have felt that sting many times in my life, and I will tell you what I have learned. The sting is real. You do not have to pretend it doesn't hurt. It does. There is something particularly sharp about being dismissed by someone who hasn't yet lived long enough to understand what it costs to build a life with integrity, who hasn't yet failed hard enough to know what real knowledge feels like. But here is the other truth. That sting is information. It tells you exactly who you are dealing with. It tells you exactly where the weaknesses are. And if you have spent decades building something real, real knowledge, real skill, real character, then that moment of dismissal is not a wound, it is an opening. Nathan Voss gave me an opening that morning when he made that remark. He told me he wasn't taking me seriously, and that meant he hadn't prepared for me. He hadn't read as carefully as he should have. He hadn't anticipated the folder on my bench. His arrogance was his blind spot, and I walked straight through it. The verdict took less time than the insult. I awarded Patricia Delgado her full deposit, the contract penalty, and reimbursement for the emergency contractor she had been forced to hire to make her kitchen habitable while the case was pending. I also issued a formal referral to the state licensing board recommending a review of the company's contractor license given the pattern of complaints on record. And then I looked at Nathan. Mr. Voss, I said, you are a capable attorney. That is not in question. What is in question is the use you have made of that capability. You chose a client whose business model depends on finding people who are unlikely to fight back. You walked into this courtroom this morning planning to use charm and speed to move past the evidence. And when you thought the person on this bench might be slow enough to let you do it, you said so out loud. He was very still. I am going to say something to you that I mean seriously, I continued. You are 41 years old. You have real talent, and you still have time to decide what kind of attorney you want to be 20 years from now. The kind people avoid in the courthouse hallways, or the kind they trust. I paused. Today was not that decision, but today can be the day you start thinking about it. He didn't respond, but something in his face changed. Not dramatically, just shifted. The way a person's expression shifts when they hear something they did not expect, something they were not defended against, because they had not prepared for honesty. The gavel came down once, clean, final. This court is adjourned. Patricia Delgado stood slowly when it was over. She gathered her papers with careful hands, and when she looked up and our eyes met, she nodded. One small, certain nod. The nod of a woman who came into a room afraid and is leaving it with something restored. Not just money, something harder to replace than money. The feeling that the system saw her, that her age and her gender and the quietness of her voice had not made her invisible, that someone behind that bench had looked at the contract, read every line, understood exactly what had been done to her, and said, "No, this is not acceptable. You deserve better than this." I held her gaze for a moment. Then I gathered my own papers and walked back to my chambers. I heard later that Nathan sat in the courtroom for a while after everyone else had left. The clerk mentioned it, not dramatically, just in passing, that he had stayed behind and seemed to be reading through the contract again, the one with the clause he should have read more carefully the first time. I do not know what he was thinking in that moment, but I hope he was thinking about that retirement judge's letter, the one I never read aloud, the one that said he preferred targeting older people because they didn't fight back as hard. I hope he was reconsidering that strategy, because I am 76 years old. I have been in more courtrooms than he has had years on this earth. I have read more contracts, heard more cases, and seen more human deception in more creative forms than any YouTube clip or legal drama could ever prepare a person for. And I fight back, not with noise, not with performance, with preparation, with patience, and with 50 years of knowing exactly where to look for the truth in a stack of papers. That is what age gives you when you use it well. Not slowness, not confusion, not fragility, precision. There is something I want to leave you with. We live in a world that worships the new, the fast, the young, the loud. A world that sometimes looks at someone with gray hair and years behind them and quietly decides that their best days are behind them too. I have watched that assumption destroy more arrogant people than I can count. Not because age makes someone untouchable. It doesn't. Older people make mistakes. We have blind spots too. We get tired. We miss things sometimes. But experience, genuine experience, the kind earned through thousands of real cases, real failures, real lessons, that is not a liability. That is the most powerful tool in any room. The trouble is, it doesn't announce itself. It doesn't perform. It doesn't have a social media strategy or a catchphrase or a perfectly timed smirk. It just sits quietly, reads the documents, waits for the right moment. And when it moves with a precision that youth and arrogance simply cannot match. Because youth learns from textbooks. Experience learns from being wrong and from being underestimated and from sitting across from men who believe their confidence is a credential. It is not. Confidence without preparation is just noise. And in my courtroom, noise has always lost to evidence. It always will. If this story reminded you that age is not a limitation, it is a library, drop the word sharp in the comments right now. And if you know someone who has ever been dismissed, underestimated, or talked over simply because of their age, share this with them today, because they deserve to know that quiet strength is still the most powerful thing in any room.